Organized money.
Please like, subscribe, and hit the notification button so that more people can get exposed to organized money. Really appreciate it.
So, Matt, I am so old. I remember our first episode of Organized Money. It was in 2024. Flying cars hadn't been invented yet. And we were actually talking about some history, the history of the case against Google, and how 10 years before Google had to sit in a courtroom in Washington, D.C. and defend its conduct, Google's lobbyists, Google's lawyers, Google's associates and their allies got a case kicked out, basically, at the Federal Trade Commission that the staff thought should have been brought, basically charging it with being a monopoly.
Right. And so we talked about that. One of the things we didn't talk about when that, what happened with that case is what it did to the broader antitrust environment. And in fact, it led, and we're going to get into it in this episode, it led directly to the revival of this form of law and the systematic sort of attack on big business monopoly power that we've seen in our corner of the world over the last 5 years.
Yeah.
Because one of the people who was working on that case as an attorney in private practice, trying to get a case brought, was our guest that we're going to have on. We had him on last week. This is part two. Jonathan Kanter, who very impressive guy. Last week, we focused on his experience at Big Law because we were talking about Big Law. This week, he was, I think the much more important thing that he did, which is he ran the Antitrust Division under Biden for 3 years or so.
Right. Yeah. So in 2013, as you say, he was working on these Google cases, but from the perspective of someone who was in private practice, working with companies who wanted to see Google taken on by the government. And when they weren't, he really was extremely disappointed in this and sort of, devoted his life to making sure that we wouldn't miss that opportunity again. And then he gets the opportunity to do that. And he does not miss. He sues Google, or he continues a case that was brought by the Trump administration, but also brought another case against Google. And he didn't stop at Google. And it was not just tech. And he did a whole bunch of stuff that really reoriented how the Justice Department's Antitrust Division looks at the economy, how it looks at mergers, and how it looks at its role as defending the public from the negative impacts of economic concentration. And so he was so good on Big Law that we wanted to ask him about something he knows even more about, which is himself. And so we had him on. This is part two of our discussion with Jonathan Kanter. Here it is. This is Organized Money.
Well, Jonathan, I want to talk about the times when you kick the tail of these big law firms up and down. You faced off against a lot of lawyers from these firms who represented some of the biggest companies in the world. And I kind of want to know what that is like. I was talking to someone who was telling me they were in discussion. I think it was during the Kroger Albertsons trial. And they were in discussion with one of the lawyers representing Kroger and Albertsons. And they asked him, how many suits did you bring to this trial? It was like a 3-week trial. And the guy said, I think I brought a dozen suits. And the person talked to him who was working for the government said, I brought one because that's the only one I have. So I think it's a good way of kicking this off. What is it like to go into a room and see this phalanx of lawyers, all with a dozen suits in their hotel rooms, clicking off all these billable hours? Like, how do you, as someone who works for the government, who has a hard cap on your resources, deal with that?
I love it. So necessity is the mother of all invention, right? And it's a challenge. And
I always used to tell people when I was in the private sector, and certainly I agree with this, or believe it more than ever, which is you underestimate the government at your own risk, not simply because they're the government, they have the shine of representing the public. It's because they're damn good at what they do, right? And so part of the Department of Justice, for example, its allure is has prestige. And people want to go work at the Department of Justice. They get great experience. They get to do things in their career that they would otherwise not have the opportunity to do in at a law firm, and they get to do it at a high level. And yes, it's on a shoestring, but that means they get opportunities they otherwise wouldn't have. They get great training. They get great access to documents and materials and all the kinds of things that actually make you technically a very good lawyer. And so when we went up against these big firms, we recognized that the way to succeed was not to make those firms worse, but to make ourselves better. And so we built, for example, a litigation unit of 25, a core of 25 first chair trial lawyers, people who grew up in courtrooms, who can go toe to toe with any litigator in the country. And we built a center of excellence inside the Antitrust Division to make sure that we were using those folks alongside our antitrust experts who were focused on trial first. And what we found was often because there were so few antitrust cases that the government brought, we had more experience than they did. And that our experience ended up outshining a lot of those law firms in the courtroom. And I'm really proud of what we did.
That's great. Do you think it's a mentality, like a mindset in terms of, the lawyers who come to represent the government in these cases? Do you think there's a particular kind of connection in mindset between them that puts you in that position that you want to be more of a killer, I guess?
Hell yeah. So when you stand up in court and say, my name is Jonathan Kanter and I represent the United States of America, that sends chills. It gives you chills. You feel motivated. You feel like a real life superhero. That shit really works. It really makes you feel good about what you do. It gives you a sense of mission and purpose. And then you remind yourself that I'm here to represent the public and they trust me to do a good job. And so that stuff works. And I don't care, if you have one suit or 57 suits, if you have that kind of mission driven sense, it motivates you to be better. And people like the people who are at the government, right? A lot of them can get jobs working anywhere else. They're there because they believe in what they're doing and they're good at what they do. And it's one of the reasons why I've been so disheartened by this effort to discredit, the importance of, people who work in the government. I mean, again, there can be problems with government. There can be people who are not good at their jobs, just like anywhere else. And there certainly can be inefficiency, but I will say that by and large, we worked as a team and we did really well because we viewed these formidable opponents as a challenge that we wanted to take on, not as something to be intimidated by.
So, okay, so let's take the other side of the coin, right? So one of the things I've noticed about the big law is they tend to be defense oriented, right? You're typically not going to be bringing a case. You can bring antitrust cases as a plaintiff if you want, but those are kind of usually a different kind of lawyer. That's not always true. There are some big law firms that bring monopolization cases. Increasingly, they're doing that, but that wasn't the case until relatively recently. But one of the things that we do see is that, sometimes they want you to take, like, these lawyers, they go to you as an antitrust division chief or at the FTC and say, hey, we have this problem with this company that's doing things to us. We would like you to take them on, or we would like you to block this merger or something like that, right? So they're not always kind of trying to prevent antitrust law from working. Sometimes they're on the other side, right?
Well, yeah, I mean, which makes a lot of sense. For every monopolization case, for every one company that we were investigating, there were probably 24 companies that wanted us to do that investigation. And they weren't all people just looking for a leg up in the market. They were customers. There were people who feel like they were being overcharged. There were entrepreneurs, people who wanted to invest and innovate. There were small companies, medium-sized companies, big companies of all different varieties who wanted us to enforce the antitrust laws. The dirty little secret is that unless you're the monopolist, and you're in business, you view antitrust enforcement as good. I went and did a speech in front of the Chamber of Commerce, and I thanked them. I thanked them for all the great information that they brought to us. And then I handed out kind of fake glasses and mustache, like the Groucho Marx thing. And I said, a whole box of them. And I said, here you go. Next time you come in, you can put those on so nobody sees you. But the truth of the matter is, they are the ones coming in, giving us the information that we need to bring these cases, and they are testifying on our behalf, and they are happy that we are bringing these cases because they view our work as helping them compete more effectively, helping them innovate, giving them a path to success in industry.
That's hilarious. I want some of those glasses, and I'm going to look out for people that are strangely looking like Groucho Marx in Washington next time I'm there. I want to talk about another speech you did. It was one of your first speeches, I believe, when you took over the Antitrust Division. And it was before the American Bar Association antitrust section. And you kind of, and you've gone over a little bit of this previously, but you basically said you don't work for them, that you work for the public, and that's your client. And you were kind of saying this, that the thrust of your argument was that we've cloistered antitrust in such a way. The language is very technical. Ordinary people are left out of the conversation. They're excluded because it's hard to understand. And then you made sure that talk was live streamed. So people who weren't elite lawyers who were in the ABA could actually watch it. And I'm curious why that was one of the first things that you decided to do, and what it meant to the public at large, but also what it meant for you to say that to that community.
Yeah, it was my way of saying, my name is Jonathan Kanter and I represent the United States of America, right? I'm a lawyer, going back to our conversation about law firms, and I have a client, right? And I grew up in a world where just like a doctor has a patient, I'm a lawyer and I have a client. And my job is to step in front of a train if I have to in order to protect my client, doing everything that is necessary, proper, advisable, and ethical. But when the public is my client, I'm going to take that same fervor, that same commitment, and make sure I'm doing everything I need to do in order to protect the public. And so my client deserves access to the government. My client deserves access to information. My client, the public, deserves the opportunity to participate, provide its views. And it is important, and I kept a compass on my desk every day in the DOJ to remind myself of this, to remember at every turn that everything we do has to be done in order to represent our client, which is the public. And I think in a technical area like antitrust, it gets very easy to become insular and focused on trying to make sure that you look good in front of people who are quote unquote smart, and lose sight of what your real job is, which is, in my view, to make sure that I'm delivering the best possible outcome for the public by holding wrongdoers accountable and making sure that markets are competitive.
Okay, so let's go through your greatest hits as Antitrust Division Chief. I always find it weird to say Assistant Attorney General for the Antitrust Division. That is just too long. We need to change the title. And I think Antitrust Chief is best, but I'm just...
Antitrust Czar? Maybe?
What did you call yourself? You clearly didn't call yourself that, but what'd you call yourself?
I call myself the head of Doge.
Really? I feel like that's not true.
No, it's not. But I will say this, I ran the Antitrust Division for 3 years, zero cost to the taxpayers and with a budget surplus every year. So if someone wants to talk about government efficiency, I'm here. Give me a call.
Okay. So greatest hits. All right. Enough bragging, right? I love Elon Musk. I'm not gonna hear any ill talk about him, his inefficiency, you Democrats. Okay. So you sued Ticketmaster, Live Nation. What do you have against great live events productions? No, I'm just kidding. What was that suit about?
So that suit was about a company that monopolized the live music industry and comedy industry from end to end. It's not just about ticketing and junk fees. It's about owning the ticketing. It's about owning 60 out of the 100 largest amphitheaters. It's about owning the promotion. And it's about making sure that anyone who wants to compete at any of those levels not only has to compete at all of them, but can't enter the market or offer a better product or service. And so it was an example of this kind of tyranny of the intermediary, which is something we encountered in a lot of our cases, where you have these middlemen who grow up, monopolize all the different portions of the middle, and then screw consumers, screw artists, and screw venues.
So what Ticketmaster Live Nation was doing that was illegal specifically is that, like, if you're an artist and you want to play at a venue that's owned or controlled by Ticketmaster, you also have to use Ticketmaster software and promotional stuff, right? Like tying those
Correct.
things together. Okay.
Correct.
So it's not that they like own a lot of stuff. It's that they just sort of don't let you into the market.
Well, it's right, exactly. So not only
Okay.
do they own a lot of stuff, but they also say that if you want access to our promotions, then you have to use our ticketing.
Right.
If you want access to the venue, which uses our ticketing, then you have to use our promotions. Or if you want access to our, amphitheaters for your summer tour, then you have to use all of our stuff. And like it's this sort of any way you turn, you're sort of stuck in this Ticketmaster vortex.
Now let's talk about Google. Obviously, this is one of the few cases that actually, at least the liability phase wrapped up. So you brought two suits. One of them, Google was found to be a monopolist. One thing that I think is interesting that I've heard is that you were kind of radicalized when the FTC dropped its case against Google around similar issues that you brought, close to a decade later. Why did it take so long to go after Google, I guess, number one? And number two, how do you think these cases will end up? It's very interesting that the current administration's Antitrust Division did not fundamentally change the remedy request that they made to the government. So there does seem to be some continuity there. So tell me about that.
So just to level set, we had two separate lawsuits. One was the Google search case, which is where the Justice Department sued Google for illegally monopolizing the search market and portions of the search advertising market. That case was initiated in the Trump administration. We litigated it under my supervision and we won. And we won big, and now we're in the remedies phase, or the DOJ's in the remedies phase. Then there's a second case that we brought that relates to Google Ad Tech, and that's essentially that advertising is not sold like the old madman era. It's really sold like a commodities or equities exchange where you have buyers and sellers buying in real time and bidding. And the allegation is that Google represents the buyers, they represent the sellers, they own the exchange in the middle, and they buy and sell on their own exchange, and they're manipulating the market effectively. So we brought both of those cases. The latter is we're awaiting a decision, but the team did an extraordinary job litigating it. Going back to sort of the history here, the Antitrust Division, or rather the FTC, had investigated Google about 10 years prior to the cases being brought. And they gave Google what appeared to be a clean bill of health. And I was at the representing companies advocating for the government to bring that case, and was extraordinarily disappointed when it declined. But it also revealed for me the reasons why the government did not bring that case. And the reasons were, overly deferential to Google. It was rooted in this ideology that, oh my goodness, the worst thing we can do is interfere with the market, and that a false positive is much worse than a false negative, which had been an ideology that permeated antitrust for most of my time in the profession, and that it's better just to do nothing because markets will self-correct. And the reasons that the FTC used to give Google a pass were not only wrong as a matter of law, they were wrong as a matter of fact. And they just didn't line up with the market realities that I was seeing on the ground. And that was happening at a time where we saw these big tech companies who were the darlings of Washington, becoming very invasive with respect to privacy, very controlling with respect to their influence in politics, and extraordinarily powerful in terms of the free flow of information and influencing the public discourse. And I became very concerned that in the absence of strong antitrust enforcement, these companies would grow to exert too much power over society, and it would be highly problematic for us, not just as an economy, but for as a free society.
Well, I'm glad that didn't happen.
Woo. Missed that one.
So good that we avoided any problems there. Um, so uh, let's go to Apple. So we're
Yes.
going through your greatest hits, and so we got Ticketmaster. We talked a little bit about Google, Apple, right? While you're taking down great American institutions, right?
Yeah.
Why do you hate my awesome iPhone? What happened there?
So yes. So the allegations again, Apple is a massive company that takes money everywhere. It takes a percentage of, the tap to pay transactions. It takes percentage of the App Store. It takes a heck of a lot of money to buy the phone itself. It even takes $20 billion plus a year from Google, according to court filings. And so, and so it is extracting a lot of money for the same device. And that is money that is not being reinvested in the economy. Apple is, sitting on, many tens of billions of dollars in cash. In our filing in the Apple complaint, we talk about how Apple spent more than 2x, twice as much on stock buybacks than it did on R&D. And so the company was being highly extractive, and it was maintaining that monopoly, as we allege, not by making a better product, but by imposing restrictions on how other people can build their products, whether it's how someone can design their watch that competes with Apple Watch, how app developers can design their apps and how they want to list their services, how they want to accept payment, how they want to link people off the device. Our allegations were, again, that Apple was essentially regulating the industry to make it less innovative. It was telling people what they could and couldn't do with respect to building their products, and it was charging them a big tax. And when they wanted to come up with ways that circumvented Apple, so they didn't have to pay the tax, Apple would pose new rules, not to make the Apple product better, but simply to get more money from third-party developers and to force them to pay the tax.
So a lot of questions about Apple, but I want to follow up with that because I think when you made the point about stock buybacks, you also noted that there were internal Apple executives saying, essentially, stop making the product better. We don't have to make the product better. It's expensive to do that, and people will buy it anyway. And what was striking about that isn't, and I wrote that up when you guys came out with that. And this is a common thing, right? You don't have quality improvements. You don't have as much R&D and whatnot. And also, even when there is R&D and they invent cool stuff, they often they don't deploy it because they don't have to. But one of the things that's been really interesting is to see the Chinese catch up and surpass us in certain technological areas, and a lot of them actually. And I think you saw that with AI and DeepSeek and Baidu and others coming out and actually improving and getting better on some of this stuff, or cheaper. But also, Apple itself had what I think is kind of a Boeing moment within the Apple kind of pro-Apple community. They really freaked out, I guess, a month ago when Apple announced that, they had said, we're going to come out with Apple Intelligence, which is basically a better Siri, where like you're going to be able to say, Siri, who was that person that I met at that party last week? And it would be able to tell you, and that's what AI can do. And they just announced, they promised that, I think, last year or 2023. And then like last month, they said, oh, actually, we can't do that, or we're not coming out with that for a while because we can't figure it out, which Apple never does. They never announce something they can't do. It's usually almost done by the time they announce it. And so this was a major catastrophe. And even the most pro-Apple people were like, this is a disaster for the company. It's embarrassing. The person who ran Siri was basically pushed out. And it's a crisis. And the Apple and tech people, like tech journalists, were talking about it. But you essentially laid that out in the case, I don't know, a year or two earlier, saying this is not an innovative company anymore. So why do you think it's so hard for tech journalists, for tech thinkers to kind of understand that what antitrust is about is improving technology and making things better? And why didn't they reference the Apple antitrust case and say, oh, maybe those guys had a point? Because a lot of these people were really dismissive of the case that you brought.
Yeah, it's strange because if you ask people in the industry what they thought of our case, they were all, universally positive. People who have to deal with Apple were extremely concerned about the control that it was exerting and its inability to innovate, or not, and Apple's inability to innovate, but instead its focus on trying to lock in others and extract more from them. So I think there's a sense that, oh, I like my iPhone, right, and therefore I don't want the government to mess up my iPhone. But we were never looking to mess up the iPhone. We wanted it to be better. We wanted competition and innovation to, force it to try harder, offer better products at a cheaper price, and be more innovative. So, it's hard to say why the media did or didn't cover it, but I think we've been proven right. And then if you look at you alluded to this map, but in our complaint, we talk about how there were documents where Apple said it just needs to be good enough, right? And good enough compared to what? Well, good enough compared to the next best competitor. But the other part I think is really important here is it's really hard for big tech platforms or any big company that, for that matter, to innovate because they have to bring their whole ecosystem along with them. So if you're a company like Apple and you have a massive install base of phones and iOS devices and iPads and watches and headphones, every time you make a change, it affects the entire ecosystem. And so when you're innovating, not only are you mindful of what might do to cannibalize your sales in one product or another, but you run the risk of breaking your entire ecosystem. And so these companies get very risk averse and they get slow because it's just harder. Whereas startups or smaller companies that are not conglomerated have much more freedom in how they innovate and introduce new products. And it's one of the reasons why these companies tend to be more disruptive. Another case we had was Adobe Figma. And that was the whole purpose of Figma. It didn't have the sort of weight of the Adobe Creative Suite behind it. It was able to innovate kind of in a cloud-first manner that was really built in order to take on Adobe. And it could be lighter in terms of its software, it can be more nimble, it can be more user-friendly, because it didn't have to innovate on top of an existing platform.
Yeah, and Figma just went public.
Yes, we need more public companies. Damn it, we need more. We need more.
Make the NASDAQ great again.
Exactly. But why is the Mag 7 not the Mag 17? Right. And if you had more of these innovative tech companies not being bought out, but instead going public, you'd actually have more competition and you'd be generating more value, not just for consumers, but for markets too.
That's spoken like a CNBC contributor. But it's interesting because we're actually in this huge R&D moment among big tech. There's probably going to be $1 trillion in spending, and it's all geared towards dominating AI. And what we found, and Matt alluded to this with DeepSeek and these other largely Chinese innovations, that there was an expectation, I think, from these companies that all we have to do is throw money at this. We have the data, and we're going to win. And what we found is that actually the data didn't matter as much as the kinds of issues that you're talking about, the sort of sclerotic nature of giant companies sort of pivoting their strategy all at once and having to deal with all their legacy business lines in that process. So I mean, do you see what you sort of laid out in the Apple case as an object lesson for why we're seeing this kind of bubble in AI that may not pay off?
It's a significant concern. If we become too dependent on a small number of companies in order to quote unquote beat China, not only are we going to have too much market concentration, but we're probably not going to quote unquote beat China, right? We are at our best as a country when we are letting new ideas come to the surface through innovation. And so, I mentioned the Adobe Figma case because it's the same theory as Apple. It's the same theory as all these cases. You want these new innovative upstarts to essentially have the flexibility to innovate from the ground up, find necessity is the mother of all invention, find a new way to do something cheaper and disrupt. And too often the dominant platforms, because they can't move quickly, are more interested in slowing innovation in order to suit the kind of aircraft carrier nature of their business model, rather than figuring out how to build a speedboat.
Yeah. Continuing the greatest hits, there's this guy, this economist named Noah Smith, and he was all mad the other day because he said, Lena Khan was too busy with big tech and didn't go after meatpackers. Why didn't she go after meatpackers? And he's ignorant, so he didn't know that you, in fact, went after meatpackers. So I'm going to give you the opportunity to enlighten Noah, because I know he's listeing.
This is us being petty.
Could you
trying
explain?
To embroil you into our internet beefs.
Yeah, we're sorry. Well, I'm very sorry to ask this question.
No, but there is this general feeling though that like, oh, they just were going after big tech. Why didn't they do the real things like meat and wages and food and energy and blah blah blah? So like,
and you did all that. So we wanted to give you the opportunity to talk
so
about
we did ocean shipping, we did agriculture, we did real estate. I mean, we did tickets. Big tech was the stuff that got a lot of the attention, but we brought this great case against a company called AgriStats, which was essentially a data repository hub that led to, our allegation was essentially propping up the prices of meat products and reducing the opportunities for farmers to get a return on their investment. It's probably the most important case that nobody's ever heard of in the agriculture industry. We brought cases involving the ability of farmers to switch from one meat processor to the other without having to have these massive loan repayments or massive contractual restrictions. We bought cases involving meat processors and their mistreatment of workers. We had a whole range of cases. I will say this, I wish we had done more. I wanted to do more, and I wish we had more time to do more. So in any of our areas, part of being in a job and having deep passion for it is you see all the things left to do. And it's hard to spike the football when you see a lot of problems in the marketplace and we wish you had more time, energy, and resources to address them. But the idea that somehow we spent all of our time on big tech is misguided and is a fundamental misunderstanding of what we did with our time there. We brought lots of cases in lots of different areas. And we focused on, again, defense, we focused on housing, we focused on agriculture, we focused on finance. We hit all of that stuff. Some of the things that grab the headlines tend to be big tech, but that's just the way it works.
So I remember, you brought one of the last cases, I think you brought it, was United Health Group. It was a merger involving United Health Group and a nursing home chain. Amedisys. Yeah. I don't never know how to pronounce that company.
Yeah, it's Amedisys.
Corporate consultants, please make pronounceable names of companies when you rebrand for some scandal that happened. Okay, so you brought that case, and one of the interesting things about that case is that it really wasn't very remarked. It was a big case, but because you brought so many cases, and I think in any other regime, it would have been like, this is my major legacy. But because you brought so many cases and your counterpart at the FTC brought so many cases, it was just like Tuesday, right? That's what it was like. These cases, they just kept coming. And so in any other administration, these legacy defining cases were just one more thing that you did. But I want to actually ask you about, and I think this speaks to your secret superpower, which is that you were not afraid to lose. I think that a lot of lawyers and government people and legislators, we're all kind of afraid of getting embarrassed, right? That's the one of the things that elites are. Everybody's frightened about, but elites in particular. But one of the cases that you did lose that I thought was worth bringing, and I wish you had won it, but it's important to bring it anyway, and it speaks to something you did that was legally innovative, was the case against the CEO of DaVita, which was the dialysis company, right? And you brought it again. And dialysis is like such a dirty business, but you brought it against him for violations around labor, which is not considered usually traditionally an antitrust thing. Usually labor is like labor law, wages and stuff. So you resurrected this tool, or not resurrected, you created a legal tool around labor and using criminal law. What was it? What did you try with DaVita and other things? And kind of what do you see going forward with that area of law that you fostered?
It's a critical area. So I think we brought a number of cases, both criminal and civil, relating to labor. On the criminal side, we had a lot of success in terms of convincing judges that the legal theories were sound. And we got
what did you allege with the CEO of DaVita? Let's just start with the basics.
Yeah, I'm not going to get into the criminal cases. So
okay,
yeah,
generally speaking, theoretically, not that case in particular, but what was sort of the broad?
We brought a whole bunch of cases where companies would get together and say, we're going to screw workers by agreeing either not to recruit them or to fix their wages.
Okay, so that's the legal violation there. Okay.
That's the legal violation. And it's just like price fixing or market allocation, except instead of customers, it's to workers. That we also brought merger challenges, including the Amedisys challenge, but also the Penguin Random House Simon and Schuster case, where the concentration of power would give the merged entity more control over workers and have the ability to screw them. And we won the first ever antitrust case based on harm to workers, in that case, authors.
Yeah.
Where the Antitrust Division is actually in court right now, litigating a labor case in Las Vegas that we filed. And we've learned a lot in terms of how to litigate these cases. We had a lot of experience litigating consumer cases. We had less experience litigating labor cases. And so while we had these really well-crafted theories on the criminal side, we had some challenges getting juries convinced that these were worth potentially putting somebody in prison for. And so we've learned a lot, and we retooled our approach to those cases to make them compelling to juries in a way that's consistent with the legal theories that were actually quite successful.
And another interesting thing that you resurrected kind of at the Antitrust Division was this whole issue of what is known as interlocking directorates. So Section 8 of the Clayton Act says that you can't have the same person or a person from the same company on different boards of companies that compete against one another. And you went after this, particularly around private equity representatives on various different boards. Tell us about that. And do you think that had a deterrent effect against this kind of thing continuing to happen?
Huge effect. So this law had been in existence since, I think, 1914, the Clayton Act, Section 8, but had never been systematically enforced. And the interesting thing about this interlocking directorates law is that it's not hard to enforce. You don't have to prove competitive effects. You don't need economic experts.
You look at a chart.
Yes.
That person and that person.
Either you did it or you didn't. And if you have the requisite amount of sales and there's some like little basic math you have to do, that's all it takes. And it's really, in many respects, the fastest way to deconcentrate industry is by breaking up these interlocking directorates. And so we put a team together and we found a whole bunch of examples. And we sent a whole bunch of letters out saying, you better remove these interlocks or we're going to take you to court. And they started removing the interlocks. And we had a bunch that we announced. There are a bunch others. And I've heard from many companies and lawyers that now that we're enforcing the law, they actually adhere to it. Now, I'm sure there's still plenty of violations out there. I think there's a lot more to do on this area, but it was like fish in a barrel.
Yeah. So 2 questions, and this is kind of about administrative, has this been successful, like the antitrust cases? And I guess one question, let me make the pro side and then the con side, and then I want to get your take. Okay, so the pro side is, wow, Google was found liable for being a monopolist, right? And that's a big deal. It's the first monopolization case against a big tech firm since Microsoft in the 90s and against a major firm period. And they were found liable. And now there's a remedy phase. And this is a big deal because now a lot of companies in the economy are like, am I doing something similar to what Google is doing? And you see a whole bunch of monopolization cases that have been filed in the last couple of years against companies like Epic Systems and NASCAR. And, I can name them, but I don't have them all off the top of my head. Dave, maybe you do. But Ultimate Fighting Championships. There's one that just got filed against tennis. There's like a ton of monopolization cases that are coming on the private side, right?
On the private litigation side,
right? Private. So that's a big deal. But here's the con. Okay, the con is, well, Google, Trump started investigating that in 2018 or 2019, and it's 2024. They finally get, found liable. 2025, there's a remedy. It probably will be done by this summer. Then there's going to be appeals. And by the time stuff gets implemented, right, even best case scenario, it's going to be 2027, 2028. And, that's almost 10 years. It's 9, 10 years. And, or, and, and that's, another 500 billion to $1 trillion of profits that Google has made just in the time that it's been under litigation. And also, they've just been squatting on the market for a really, really, really long time. So what, how has it been successful? And then how do you get these cases sped up? How do you, if there had been a second term of, if Kamala Harris had won and kept you on and said, what do you need to make this work better, or you just continue doing what you're doing? How would you have seen this helping the economy kind of more broadly? Why does it take so long?
Yeah.
The question is, how can we create abundance in antitrust?
Yeah, can we create more? We need to talk about zoning. Sorry. So
it's all about permits.
Yeah.
So let me address the pro side, which is, yes, I agree with you. And some instances, the best remedy is the case, right? When you enforce the law, it becomes real and people start to comply with it. And if you look historically, AT&T took a long time, IBM, which had a bunch of remedies, took a long time, Microsoft took a long time, but AT&T kind of preceded the dawn of IBM. IBM preceded the dawn of Microsoft. Microsoft case preceded the dawn of Google. And now the Google case is likely to precede the dawn of AI. And what I take away from this, and many other things, is that when you have these paradigm shifts in technology or networks, companies have a great incentive to keep those new emerging technologies and competitors and competitive threats from thriving using anti-competitive behavior. And it's at those moments of change, it's really important to make sure that you have a cop on the beat, policeman at the elbow, to make sure that the incumbents are competing their way to these new markets, not stifling them using anti-competitive behavior. And so when we are there enforcing the law in front of a court, I absolutely believe it makes a difference. But I also agree that we need to go faster. And we tried to do that. And we were working on that. So for example, the Google ad tech case was filed. I filed that in January 2023. And we were in court at the Rocket Docket in Eastern District of Virginia in a much faster time frame. We filed the Ticketmaster case in the Southern District of New York and have a very speedy trial calendar. It's going to get to court in 2 years. And so while that's not fast by most non-legal standards, they are faster by legal standards. And so we were getting also more thoughtful about how long we investigate and what standards we need in order to bring cases. And we got much more efficient. Hello, Elon. In how we investigated cases, how we used resources. I think there was a tendency when you brought fewer cases to over-investigate them and overstaff them, which resulted in, I think, the investigations not only taking a longer time, but becoming more bloated and less effective. And sometimes shrinking the team actually makes the case go faster, the investigation more refined, and gets you to a decision point, in a shorter time frame, and allows you to file the case sooner.
So, I mean, the other part of this, I think, and maybe this is a good place to wrap up, is whether or not the work that you did will be carried on in this next administration. Currently, we're seeing with the DOJ Antitrust Division, they're bringing cases, merger challenges. They've kept the merger guidelines that you put together along with the FTC in 2023. DOJ announced an inquiry into egg production, and egg prices immediately dropped, which I thought was an interesting way in which the deterrent effect manifests itself. Are your hopes high that we will see, at least some continuity here, where we've seen it nowhere else in the government, but in these sort of discrete areas? where you won't have to have a situation where the next person that comes in who may be thinking along the same lines as you has to start all over.
Right. When a change is occurring, it feels like it's taking a long time. But when you have the opportunity to step back and look, you realize how fast it is. And I think we've made a tremendous amount of progress. And when we built our antitrust program, we did it with really some fundamental ideas in mind. One is we're going to use the rule of law. We're going to focus on the language of the statute. We're going to focus on cases. We're going to focus on people first, not corporations first. And we're going to focus on the industries that matter the most, like tech, healthcare, defense, food, agriculture. And it turned out to be extraordinarily popular. And because we took an approach that was sound, administrable, and frankly effective and popular, I think we're seeing the kind of continuity from one administration to the other. And I'm pretty confident that we're going to look back, 50 years from now and compare, for example, 2000 to 2025 and realize that in that period, we went from a very lax antitrust regime that led to major amounts of corporate concentration to the detriment of society to an enforcement regime that opened up markets and marketplaces. And while it took time to get there and reverse the negative effects of too much concentration, I think history will judge it as an effective antitrust program and one that was good for our economy.
Yeah, I mean, we'd be here all day if we did every single case in depth. But could you talk about maybe a few others that you were able to do there at the Antitrust Division, why they were important?
Two major airline cases. We blocked the first airline merger in the history of the Antitrust Division. We brought the first Packers and Stockyards Act case in the history of the Antitrust Division. We brought the RealPage case not only to bring down rental prices, but the first algorithmic pricing litigation brought by any of the federal antitrust enforcers. And we did it using data scientists to unpack the algorithms.
That was against landlords and
landlords and landlord software. Exactly.
Okay.
We brought case against Visa. We brought case against we brought numbers you mentioned before, labor cases. We blocked a number of ocean shipping mergers. We blocked a bunch of tech mergers. We filed a record number of amicus briefs. And so we went out court by court, case by case at both the district and federal court levels to file briefs to help make sure we were moving the law in the right direction. I'm really proud of one brief that we wrote in a case against John Deere that involved in a favorable decision that will hopefully help farmers be able to fix their damn tractors for change. We pioneered interlocking directorates. We withdrew a lot of old dated guidance and we introduced brand new guidance, including bringing the merger guidelines back to the rule of law. We revived we built a litigation program from the ground up so that we can litigate against any big law firm anywhere in the country on multiple matters at once. We brought the first criminal monopolization case in over 45 years, and then we did it again, and then we did it again, and then we did it again. And we had the first ever divestiture breakup of a company for a criminal antitrust violation in the pharmaceutical area. That's just a tip of the iceberg. We did a ton more, and we did all of that in less than 3 years. We did it at zero cost to the taxpayer with a budget surplus every year, and we did it with fewer people than 1979.
And the real antitrust agenda are the friends we made along the way. Or the friends in Big Law that you lost, whichever.
Yeah, exactly.
Taking that as a pivot point, right? 50 years from now, they're going to look back and you're a historic figure already. I'm not saying it's over. Maybe you're going to be like, that was the first part of his amazing career, but and then came
until the scandal,
until the disgrace.
Wait till you hear my original music.
And then, but Herbert Hoover was a hero in the early 20s. Right?
Oh, goodness me.
This is true.
What are you
the great engineer. But just your work at the Antitrust Division is historic, and it really is a pivot point. It took a time of, you were the person who kind of really ratcheted up the revival of antitrust law in general, but also, the monopolization laws and the Google decision's a huge deal. What's next?
I have no idea. For me,
Yeah.
it's a good question. You have any ideas? No,
Well, I know that you're going on. I do have an idea because I know that you've become a CNBC contributor. So where do I pitch Kramer versus Cantor? I can produce it. Matt can help.
WCNBC. Yeah, no, I have signed on CNBC to be a contributor. I'm really looking forward to that, and I think it's going to be a lot of fun. It was important for me to take a break. I've been running at a pretty intense clip for over 25 years, and the experience of the Antitrust Division was the experience of a lifetime, but it felt like it took a few lives off in the process. There wasn't a lot of sleep, not a lot of downtime. And so, thinking about what comes next, I care a lot about the mission. I'm going to stay devoted to making sure that we can promote a good, effective, sound enforcement policy. But for now, I'm just hanging out.
Well, as
I
someone
know you're
who's-
talking to a lot of law students, and there's a
Yeah,
young.
it was my favorite thing to do at the division. I think I visited over 30 schools during my time at the Antitrust Division, and I came away inspired each time. And I was at a law school yesterday, and a business school talking to a class. I'm doing another one next week. I'll be at a different university tomorrow. I really, really enjoy the opportunity to engage with the next generation, and it gives me a lot of hope because there are people who are really genuinely mission driven, who believe that antitrust enforcement, that corporate power, that wealth inequality are the defining issues of our generation, and they want to devote their deep intellect and great sense of mission and purpose to advancing those ideas. And I think that's a wonderful thing. And if there are things I can do to help mentor or encourage people along those to pursue that, I think that's wonderful, and I'm all there for it.
Well, as someone who's unemployed, retired, I know that after you've talked this long, you probably need a nap. So we're going to let you go. Jonathan Kanter, former head of the Antitrust Division of the Justice Department, thank you for being on Organized Money.
All right. Thank you for having me. It was a lot of fun.
So that was great. I remember in 2017, you and I were both at a conference in Chicago. It's put on by the Stigler Center in Chicago. And it was the very first antitrust conference that they had put on through the auspices of the Stigler Center. And it was basically a bunch of us who thought that antitrust should actually be enforced and be more aggressive. And then a bunch of people that were handpicked to yell at us. That was basically the dynamic.
It was the conference where you and I coined the term neo-Brandeisian.
That's correct. And so among the people that were sent there to yell at us was a guy named Richard Posner, who is dead now, so we can speak ill of him.
I'm sorry, now you made me laugh at a dead. That's terrible. You're a bad person.
Breaking news: Matt Stoller laughs at dead people.
That's not fair.
Anyway. So Richard Posner gets up and he's the keynote speaker of this antitrust conference. And the first words out of his mouth are, well, antitrust, that's dead, isn't it? And he just put a damper on the whole thing. He said, I don't know what you guys are even talking about. This is ridiculous. There is no such thing as antitrust law. And that was, I think, on the second night. And there was a dinner. And after the dinner, you and me and a bunch of other people were sitting around a table, and we were just kind of crestfallen a little bit. And we were just like, everyone was so mean to us. And we were sitting here. We have no power. We have no ability to affect events. Donald Trump was just elected like 2 months earlier. There's nothing going on. What are we going to do? And at that table was you and me, and Lena Khan and Jonathan Kanter. That's who was at the table. And it took all of 4 years for them to then be in the most powerful positions regarding this issue in the entire country.
Yeah, I remember that. I actually have a picture of Lena and Richard Posner. And I believe he was holding her Amazon Antitrust Paradox article, which is kind of funny.
Which I'm sure he read thoroughly.
Yeah, well, No, Richard Posner is a historic figure, very important guy. He reoriented antitrust policy in the 70s, 80s.
100%.
So, but yeah, I mean, I think that speaks to, the one of the problems talking about antitrust and corporate power is that people are just today, they're kind of like, well, yeah, there's a lot of stuff happening on that. And of course, that's just the way things are. And then, there's like, oh, things aren't happening fast enough, or the government's never going to win or whatever. But the idea that 5 or 10 years ago, nothing was happening just seems weird to people because, we're like fish swimming in the water and you're trying to say, hey, there's water, right? But most people don't realize that we weren't doing this stuff 10 years ago. But we do because we were there being like, hey, we should do this stuff because nothing's happening. And then it actually started happening. But
Yeah,
I think
it's
sorry, go on.
it's a good sense of the real paradigm shift here, and it's represented in many ways by Jonathan Kanter and what he did, and that's what was so great about him talking to us, going through all of these things, and then realizing he just didn't even have enough time to get to everything, and that's because of this decades-long delay in trying to take control over our economy again.
All I can think of is our gross metaphors, so I'm not going to go into that. But sorry, welcome into my head. But I will say there's I'm going to have a similar conclusion as the one that we had, I think, after Lena Khan spoke, which is, this is nice and it's great that we did all of this, that he did all this stuff, and that there were all of these lawsuits, and it takes a long time. But it's also just one small part of the government, and it definitely feels more like an outline of what should have been happening across the government,
Right.
than like this one thing to celebrate in a couple of agencies that have $1 billion of budget and in a $5 trillion government. So I guess I'm like, wow, that was really amazing, and I'm really excited about it. I also think it points to a future that hopefully one of the two political parties or both will embrace this idea that this is the kind of thing you need to be doing, not just in antitrust, but kind of across all of I guess all the government, whatever's left after Trump is done. But like,
Right.
it's the kind of thing that we should be doing writ large, which is attacking these bottlenecks, these concentrations of power.
But I think, one of the last things that Jonathan brought up, these tours that he's doing on campuses and talking to law students who are really engaged and really energized with these kinds of ideas, points to that better future. When there's another government in power, that there might be able to be a situation where we populate the rest of the government with the kinds of people with the creativity and determination of a Jonathan Kanter.
I just think, as we kind of move forward and we're seeing these institutions change and we're seeing things that are successful and things that are not successful, we're seeing Trump grab onto this antitrust stuff. It's a very different moment than the first Trump term. And hopefully, I think, in many ways, some ways it's darker, but hopefully we can figure out of this how to really rebuild a theory of how to govern and how to be a vibrant democracy. And I think that's what kind of this conversation pointed me to again.
Yeah. Well, great. We're going to bring you another one of these next week, and be sure to listen. By the way, you don't have to just listen to Organized Money. We are on YouTube, and our feed, our channel on YouTube is at Organized Money, I believe. And you can watch every episode that we do. All of our conversations are up there. If that's your bag, you can check us out. And we'll be with you next week with another episode of Organized Money.
Organized Money.